Okay, our next case will be 23-3011. CBRE Inc. versus Didier Group et al. Council can approach. Hey, good morning. If I could please have council representative recognize themselves.
Yes, Honor, so on behalf of the different group. What name is file counsel or record?
Grace, mention the line. All right.
Good morning, Elliot Sherker on behalf of CBRE.
Okay. All right. Well, ballot is recognized.
You're on.
You like to reserve any time?
Yes, Your Honor, if I could reserve 5 minutes, please.
5 minutes. You're recognized.
May it please the court. First question on this appeal is whether the trial court erred in allowing Didier's claims to go to the jury and in denying CBRE's post-trial motion. On the tortious interference claim, the answer must be yes. Didier had no cognizable relationship with the Bandy Track sellers. None. The only relationship, if you can call it that appears on this record is a phone call that Didier made to the broker, Justin Hirsch. He argues that he had a relationship, however, because he wanted to participate in the deal.
Counsel, I find the facts on this, on your argument for tortious interference, very interesting. And unlike a lot of the case law that discusses the expectancy problem that seems to divide the state and the federal courts as well, both of them desired to have a relationship, correct? The jury could find that both parties desired to have a relationship.
Plumlee
And Bandy Track owners.
Well, the Bandy Track owners wanted to sell the property.
Correct. And didn't they not testify that they thought at some point they actually were dealing with Didier Group?
They did. And it wasn't all that clear to Hirsch until well into the process that Plumlee was off on his own mark.
So what's interesting here, I think, is that there's certainly case law where you have past customers, right? And ongoing relationships, and we flesh that out and how that's different. And we talk about somebody being identifiable versus somebody being part of a group. In some ways, Didier Group was identifiable.
Certainly was identifiable.
So we're not in the large customer base problem.
No, ma'am, we don't raise that argument at all.
And we have a jury that could find that both parties expected or desired to have a relationship with one another. We're attempting to have a relationship with one another. And but for a sleight of hand by Mr. Hirsch, I think a jury could find that they would have consummated a relationship. So is the argument that the expectancy only goes to the rights and not to the relationship?
If I could just
You can phrase.
put a pin in the duplicity by Hirsch part of that.
Sure.
Part of that question, Your Honor, and because we don't see that at all. But the Bandy Track owners wanted to sell their property. DG had been doing business in the area. They thought that DG would be a good customer to buy their property, no question about it. And Hirsch actually reached out to DG, and because he had other relationships with them for other separate deals. And as he told the Bandy Track owners, they didn't get back to me. They had other things going on. They didn't get back to me. And in the meantime, Plumlee, who I put going back to my pen, who was the real double dealer here, called Hirsch up and said, I want to buy the property. Hirsch wasn't clear whether he was operating on his own or operating for DG. Wasn't clear whether he was allowed to operate on his own, whether he was a partner or an employee or any of that. And Plumlee came through with an offer. Now there's the oral offer after that, as to which there's a conflict, but I recognize I'm bound by the testimony that an oral offer was made, although I found it interesting that later on, when they had the awkward conversation, Hirsch and Didier had the awkward conversation. Didier said, well, would it help if I made an offer? He actually said that in that same conversation. So I'm confused as to what he thought he was doing, but it doesn't really matter. Number one, the offer wasn't in writing. That's important under South Carolina. But even if it was, that's all there was an offer to Hirsch to buy the $995,000 property for $1 million, $5,000 increase on Plumlee's offer. That's all there was. An offer under Florida law does not create a relationship, period. End of story. And that's all he did, was make it, at best for him, was make an offer.
Counsel, if we agree with you that there was no relationship, right, and it knocks out the tortious interference claim, but if we disagree with you on the aiding and abetting claim, does it make a difference?
Well, we have an undifferentiated jury award, but we also have silence from the other side of the tuition. So I believe it does make a difference.
Can you build that out for me?
Sure. If you knock out the tortious interference claim and all that's left and you uphold the aiding and abetting claim, then I think we're entitled to some sort of proceeding. This, again, this wasn't raised by the other side, to determine what the jury verdict meant with respect to those two claims. But I think I can save you the trouble, because just as the tortious interference claim falls, so does the aiding and abetting Plumlee's deceptive behavior fall. The reason I say that with such confidence is what we have here is a broker who carried out his duty to his clients. His duty was to get the best price he could, and they wanted to sell right away. So he did that. And he's being sued for aiding and abetting because there was a disappointed buyer out there. Now that happens every day of the week in real estate deals. It's happened to me that an offer's made and someone else gets the deal. That's literally all that happened. Now, did Hirsch suspect at some point in this process, he admitted he did, that something funny was going on? And when Plumlee sent that famous email where he was trying to cover himself and said, well, tell me what else is going on here with the deal for the Bandy Tract property, Hirsch had a very frank conversation with him and said, I don't know what's going on with you guys. And I don't want to get involved with what's going on with you guys. I have a client and my fiduciary duty is to his client. So he's being sued for aiding and abetting someone he sold the property to. Well, of course, he did something to help Plumlee. He sold the property to Plumlee. The question is why?
But why is it insignificant that he did not relay the offer? I understand it's not in writing. I understand we're under South Carolina law.
Leaving that aside, as I said, this is what Hirsch knew. And I'm not here to defend him as a paragon of virtue, but I am here to say that what he knew was if he told Didier that Plumlee was buying the property, and at that point he suspected it on his own hook, it would have blown the relationship up. As he said, my deal would have cratered because I wouldn't have had the deal in hand. Now you could say, well, maybe he would have had the deal with Didier. Maybe he would, but all Didier had was, according to him, was an oral offer. And he could have said, no, I'm not interested. Meanwhile, the Bandy Tract people say, I'm through with you, and they walk. Or otherwise, there's a bidding war that goes on, and nobody's satisfied, and everybody walks away. He said, I would have blown up the deal if I told Didier, with whom I had no relationship and to whom I had no responsibility, that there was this other deal going on with his partner. And his responsibility was to the Hirsches and to the owners. And the owners very happily sold their property for the listing price. And we're talking about a $5,000 difference. Maybe the Bandy Tract owners could have gone after Hirsch for the $5,000, but they went away happy. He had no responsibility to help Didier make millions of dollars from this tax scheme by turning the property into a conservation easement. He had no responsibility, he had no duty, and he had no relationship. His only relationship was with his clients. And that's why the aiding and abetting has to fall just as much as does the tortious interference. We also raised
Counsel, if I may just jump in.
Yes, sir.
Did you at the trial level ask for the damages to be distinguished between aiding, abetting, and the tortious interference? And if so, when did you ask for that?
Not that I recall, but as I said, the issue is waived because it's not raised by the other side. And it doesn't really matter that much because they both have to fall.
Waive, how is it waived,
It's
counsel?
not in their brief.
But from a tipsy coachman perspective, if we're looking at this and we're finding that the aiding abetting is proper, my read on cases, several of them are that if we've got one version, if we've got one tort that we can uphold that has the same damages as another tort, it seems to me the cases are pretty replete that as an appellate court, we don't even, if we have a questionable claim such as the tortious interference, which I don't not concede that is the closer call. I'm not so sure that I agree with you that the aiding abetting is a closer call. That at least my read of the cases in Florida is that it's pretty clear that we can pick if we've got the equivalent damages on both. And that's why I ask you, counsel, and I appreciate you conceding you didn't raise it. But how can we not, from a tipsy coachman, be able to consider that as a grounds for affirmance?
No, what I'm saying is they didn't raise it. It's their issue.
But why did they have to wait? I mean, they're the appellee. They don't have a burden. You have the burden as appellant.
No, as appellee, they have a burden. I'm not talking about the trial court. I'm talking about here.
Correct.
The argument isn't raised here. And if an argument isn't raised in a brief, it's generally considered to be waived. But I'm flying a little bit by the seat of my pants here, Judge Smith, if I might. I don't see this as a tipsy coachman issue on a trial court ruling. The two-issue rule is an appellate doctrine with which the trial court never has to concern itself. So I'm having trouble squeezing that into tipsy coachman. But if I can just say this, as I said, I am flying by my seat of the pants on the issue. If the court is interested in the two-issue rule, I'd request supplemental briefing by both parties, very short time period, perhaps simultaneous briefs on the issue before I deal with a very large verdict on something that came up in oral argument. Because I don't concede for a minute that if the appellee doesn't raise the issue, that the court can decide it on appeal in their favor. But I also don't recollect, quite frankly, because it never came up, what the discussion was about the verdict. And I would like an opportunity to brief that before the court decided the issue.
You can continue.
Thank you. On the damages issue, we have two points. First, and this goes to the entire award. There's no basis for the millions of dollars in damages to Didier. The plaintiff's expert based his calculation of the damages on prior Didier transactions in which the profits in those transactions were allocated to partially to a separate Didier entity known as Didier Development, which has never been a party to this case. He didn't have any what he called yardstick transaction in which the only allegedly injured party was Didier Group, which is the plaintiff here. And he used both of their quote profit percentages to compute the damages without calculating, as he put it, what the split between the two entities would have been in the Bandy Track transaction. That's the transcript of pages 671 through 72. There was no damages model presented to this jury for an award of damages to Didier Group alone, and therefore no underlying factual basis for the expert opinion. And of course, an expert cannot provide the factual basis for the expert's own opinion. So without a damages model, there's no entitlement to recover those damages. They're deemed to be, and properly deemed to be, speculative. The second damages issue is a set-off for Didier's settlement with a co-defendant RCP, which was an entity created by Plumlee as part of the transaction. Didier does not dispute, does not dispute the applicability of the settlement set-off statutes, which is sections 46.050152 and 768.0412, or that identical damages were sued for against CBRE and RCP in the complaint. Of course, they can't, because the complaint says what it says. And the settlement does not allocate payment among the claims against RCP. The aggregate, therefore, the entire settlement, whatever it is, it's confidential right now, and it's the trial court did not order it to be released. should be set off against the jury award under the rule most recently stated by the Fourth District in the Cornerstone case, where a settlement is undifferentiated and general. The aggregate of the amount settlement should be set off against the judgment.
Counsel, I'm having some trouble, and I'll have questions for your opponent when it comes to the set off. But what I'm having some trouble with is identifying their argument, which seems to be that they already got a haircut when it comes to the attorney's fees against your client. So why should they take it twice? Is that what you see their argument to be?
I don't understand their argument, to be frank. But it does, the attorney's fees are over here. They're not part of the damages award. And if they want to make an argument that they're entitled to something for their haircut, then we need to know what the settlement was. Because if the settlement made them whole, despite the haircut on the damages, then the settlement walks us away with no damage responsibility.
So we
If
have,
the settlement was for a nickel, then it's something else.
so we have this rule. It comes mostly, it looks like, from the fourth DCA, that if you have an undifferentiated settlement, then we're going to apply it against the award in general. There are some situations where that makes, I guess, when you have evidence, it cannot be challenged. If you have evidence that the claim, that you have identical claims, but that the amount went toward the claims that were not identical. Let's say you have overwhelming evidence. Is there any support in Florida law that there's a process for ferreting that out?
No, Your Honor, there isn't. The answer is do it at the beginning.
Mhm.
That's what the Fourth District said in Addison. Is don't come in afterwards and say, oh, it was allocated. Do it at the beginning. Allocate it at the beginning and you're fine. If you don't do that, you run the risk of exactly this situation. That's the way you protect yourself, is by allocating among the counts. And we know that that didn't happen. That's all we know, or that's all I know. But the amount is the amount. I don't see any support in the case law for
Any alternative framework?
making them whole on attorney's fees in the context of a post-trial settlement. They're entitled to the damages once, period. And if they get the damages twice, there should be a settlement. And there's no law to the contrary.
You're into your rebuttal time.
I'm well into my rebuttal time, Your Honor. I'll rely on my brief for the remaining issues and salvage my 2 minutes.
Ms. Humphries?
Good morning. My name is Celine Humphries and I represent the appellee. I want to make an initial comment regarding the two issues that my opponent focused on the most, and that's the arguments for directed verdict and their argument regarding damages. All of those arguments are not before the court for review. Regarding the directed verdict arguments, the defendants presented an argument to the court that did not comply with the law that governs a request for a directed verdict. Their telling of the case was based almost exclusively on the story of their client's employee, Justin Hirsch. The law for a directed verdict requires instead for the movement who wants a directed verdict to acknowledge all of the evidence opposing their request, and if any of it's debatable, to construe evidence in favor of, in this case, affirming the jury's verdict. Excuse me. In response to every question you asked, and particularly you, Judge Nordella, when you received an answer, it was relying on Justin Hirsch's telling of the story. So since they brought this argument to you improperly, we don't even get to the merits. Similarly, when you get to the damages issue, they have not preserved an issue for you to review. And I was painstaking in my brief going through each point. First and foremost, as the court has identified, they're asking to undo the damage award, but this verdict form did not differentiate amongst the different damages. In my, and I apologize, very long telling of the facts, so you did have all the facts. One of the things I explained is that the profits that are earned in this sort of deal are a number of fees. They're only attacking one aspect of that, and that's the developer fees. So it's critical that this verdict form does not differentiate amongst the different categories of fees. And importantly, they didn't even ask, and I say they, different firm, different trial counsel, did not ask or request for a damages verdict form to differentiate among the fees. So we don't even get to damages at all. But there's other points too I want to make why the damages argument is not preserved. First, to the extent there was any suggestion possibly this could be a remitter, We responded in the answer brief explaining all the reasons why this was not a remitter. They have not disagreed in their reply brief, and I won't summarize that again now unless you want me to. What they did disagree is when I said, you've not requested directed verdict on damages. And they said, sure, we did. Look at the conclusion. The conclusion says it. And I couldn't reply to the reply, but the answer to that is a conclusion is not where you put your legal argument. If you're requesting directed verdict on something, you actually put it in the argument, or at least in the heading, which here the heading said simply reversed. And it's even more apparent when you compare the argument on damages to the argument on the two counts. Two counts fulsomely discussed directed verdict, never mentioned in damages. So then we go to the new trial issue. That is not available for review either. And the reason is their argument for reversing on damages is they say this is a question of law and it's de novo. And that's the argument that's repeated here. It's a question of law for you to review in the first instance. The cases they cite disprove that. So when they responded to our argument in the answer brief, they cited the ICMFG case for the principle that when the question on damages deals with a legal questions reviewed de novo. If you look at that case, Judge Wallace's case at the second DCA, it's actually dealing with the fact that there a trial court had held that a determination on liability had reached in to also determine as a matter of law, two of the elements for damages being nexus and causation. That's not here. But if you look at that opening paragraph where Judge Wallace or the Second District Court of Appeal states this principle that legal questions are reviewed de novo, if we look at those two cases, they deal with the methodology issue. Katz is the first one. And Katz says the question was, should the damages be determined based on lost profits or market value? The other case is, I just forgot the name of it. It begins with a D. It deals with whether or not the proper valuation of damages should be looking on something called reliance damages or lost profits. There was no debate here. The debate here on methodology was agreed that the expert, the plaintiff's expert used the methodology of extrapolating lost profits from previous Digger Group deals and from this actual deal when Mr. Plumlee implemented it. CBRE's expert agreed that was the proper basis. So you have that legal issue, it's not disputed. The only other legal argument that's made, and this is what CBRE focuses on, is that one business can't come to court and recover damages sustained by another business. We didn't respond to that because we agree. We don't disagree in the trial court. We don't disagree on appeal. The point here is the application of the law to that standard. Is this a circumstance where this party, Digger Group, was seeking to recover profits earned by a sister corporation? That's a factual question. That's a sufficiency of the evidence question. That was raised in the new trial motion. The trial court rejected it. So there's two problems here, right? The first is the reason why we don't even get to this issue. They ignore that inquiry, the inquiry they had to make. Even in response to our answer brief, they do not do the proper careful thing, which is to offer an alternative argument. In the alternative, even if we have to meet that standard, we could. So we don't even get to an analysis of the directed.
Counsel, can I get your position on if your tortious interference claim falls, what then? If your
So-
aiding and abetting claim stands, but your tortious interference claim falls.
So I heard two questions there, and I'm going to go to the one I think you're more curious about. But if that happens, it is black letter law that all the damages are affirmed if it is based on one count. There is no obligation for me as the appellee to tell the court what the court already knows and does and following and reviewing a verdict. So you have two different counts that are being challenged on directed verdict. All we have to do is prevail on one, and then the damages flow through. Let me say that another way that just occurred to me because I'm still surprised by this argument. If a party asks to reverse a count, saying some element wasn't proven, and the court reverses it, meaning it reverses the damages that flow from it. If a court is asked to reverse the count and the court decides not to, it affirms the count and the damages that flow for it. It's just the way it functions. There's no burden, obligation, or something I missed by not saying that to the court.
And counsel, I'm sorry, keep going.
Oh, no, you're more important here.
Set off. Can you address set off for us?
So set off, I think, is the hardest argument. I'll tell you where I'm coming from on set off, but I heard your well-taken questions.
Right, I see you're arguing abandonment. I don't quite understand that. If you could
Yes,
flesh
yes.
that out, that would be.
So
appreciated.
I think this one's murky to tell the court the truth. But I think what will happen is if you do reverse on it, we will be remanded, as counsel said, for proceedings. And what would they be? Evidentiary proceedings. So that's part of the point here, where you have a settlement. And there's no question, there's no debate that this settlement, and I understand that you know, based on your questions, there's no debate that this settlement included not only to compensate DigiGroup for the damages flowing from the harm, but to also pay DigiGroup for the fees that were owed by that party. What happens in that instance?
Wait, can I stop you right there?
Yes.
Is that also undifferentiated in the settlement agreement?
It is undifferentiated, or at least we did not dispute that. I wasn't trial counsel, but I can tell you in where it matters in the record, we didn't.
So we don't know going back, the trial judge is not going to
That's a
know.
better way. I don't know. But what I can do, and in all fairness to counsel, I did not say this in my answer brief, but what I can do based on the questions I'm hearing is if the court is aware of the proceedings dealing with ACA, where it seeks to recover Medicaid funds that it is paid for plaintiff's personal injuries, and that plaintiff settles, then there are proceedings that have even from Florida gone up to the United States Supreme Court where ACA is allowed to recover some of the recovery in order to be compensated. And I might be saying that a little too briefly, but the idea is if the state uses federal funds to pay the medical bills for somebody who's been injured using Medicaid, and then that person recovers and gets paid, the state's like,
So counsel, your position is there should be an evidentiary process where the trial judge determines what's identical and what is not.
like
Is-
ACA.
And if we were to say that, if we were to say it's like ACA, would we be in conflict with the fourth DCA?
I think you would be.
And why is the fourth DCA wrong?
I think that fourth DCA is actually, frankly, allowing a defendant to profit. So one of the things I cited in the brief, and this is the point where I probably was too quick, and frankly, it was a long brief, is there's so many cases that talk about plaintiffs cannot use different mechanisms so that they actually earn money. And you see that a lot in the collateral source context, for example. Getting injured by somebody is not, and I know this isn't an injury case, but whatever the plaintiff, you cannot use a lawsuit to actually come out ahead. You're only seeking to.
Right, there are collusion concerns.
Yes, collusion, yes. And you're just seeking to be compensated. Well, the opposite is true. It is not fair for the defendants to escape part of their obligation. So here, there would be no doubt that the jury would have decided the damages were X amount. And that is the amount that DigiGroup is entitled to receive. If the defendant prevails here, DigiGroup will not be fully compensated. It will not be fully compensated for the award that the jury determined amounts to the damages sustained. Because part of the compensation that they want credit for was compensation for attorney's fees, which was available to them under completely different reasoning and having nothing to do with the cause of action. I feel like I kind of mumbling here. Am I making my point?
No,
well?
I appreciate it. I guess, is there any sister court that endorses an alternative framework for differentiating damages?
I think this has not been addressed.
So we would be the first court to create a new framework post-trial for differentiating damages.
I say that, yes. And
then we get to why would we do that? What is the right decision to make?
Well, and that's why you look to other, so you're not the first court to acknowledge that there's an issue that the court can't determine. Said another way, it's black letter law again, that questions of fact and evidentiary issues are for the trial court. Appellate courts don't hold evidentiary hearings. There are many contexts where the court goes, we don't know.
That's true. Counsel, what's your rule? If we endorse this new framework that no court has ever found, what is the rule that we would give the trial court?
The rule is that if there's a possibility that let me start this way. We do not dispute the set-off statute applies. And we understand what the set-off is about, where a party is seeking to set off for more than the damages that are recoverable by some other amount. In other words, the set-off that they're seeking is for more than what Rice and Corner paid toward the damages.
I'm confused, counsel.
Okay, I'll say that again, because I can see why. The set-off statute says a jury determines that the damages you sustained are $100. We understand that another defendant already chipped in 20 towards it, so defendant left in the courtroom, you only have to pay 80. That's what the set-off statute says. We recognize it, and frankly, it's justice and it makes sense. But where the $20 that was received, only 10 of it was paid for the harm sustained, and the other 10 was to pay for, maybe I should adjust that, 8 was for the harm sustained and $2 was for the attorney's fees. The set-off statute does not require, and the policy behind it does not, the express language in terms of the set-off statute, so, which is obviously very important, and the policy does not mean that the defendant who's in the courtroom gets that benefit of another defendant having chipped in money to pay its obligation for attorney's.
So would the
fees.
argument be that following the fourth DCA's model does not honor the text of the statute?
It doesn't honor the text of the statute, but more importantly, and the argument I've been leaning towards is it's unjust. It means that the defendant in the courtroom is escaping its share of the responsibility for the damages occurred, simply because that settlement also included a separate claim to which that defendant is entitled to no benefit. And that separate claim, and I keep saying attorney's fees, but it's attorney's fees and costs, that they're getting the benefit of that. And that's not what the set-off statute is about. And that's letting, excuse me, CBRE escape a part of its damages that this jury determined it is liable for. That's the concern.
Counsel, you're also making an argument about attorney's fees, and could you build that out for me on how attorney's fees in here were allocated separately? Obviously, the trial judge went through what was related and what was not, and you seem to be making that they would be getting a double recovery. Is that a separate argument than the one you just made?
It is a separate argument, but what I'm really doing there is acknowledging or pointing out that they themselves acknowledge that we should separate attorney's fees when it helped them lower their responsibility for the attorney's fees. So when we came to the hearing seeking attorney's fees that incurred to pursue the trial, I do want to make sure I made this point clear. We already had cut out the attorney's fees that we thought were related only to this other party, but there were some that were debatable. They won almost that entire argument. They won a lot of that. And so they said, whatever, all the money and fees and costs you incurred for this trial, you can't make us pay those fees that are somehow particularly relevant only to a defendant who had already settled on debatable issues. So in that context, they were able to minimize their responsibility for the fees and costs that they owed after losing the trial. Over here, in the context of the damages, they want to close their eyes. That's the point that I was trying to make. Now I'm going to make another point. So I do want to hit on something. Well, when you asked your question about what is the consequence of if the court rejects the tortious interference claim, that one of the answers given to you was that means the aiding and abetting has to fall as well. And I can go through all the evidence if you want, but I want to say something really obvious in response instead, or at least first, and that is there are two different causes of action with two different set of elements. And they have different facts that relate to each. And I don't think I could have been more painstaking in lining up the evidence that at least all I had to do was establish that a jury question existed. They do not go hand in hand. But to the extent one of the arguments you heard on the tortious interference was, goodness gracious, all Mr. Hirsch was doing was honoring his duty to his clients. That ignores evidence. The most important thing, that he lied to his clients. So Mr. Hirsch testified to the jury, I told the sellers it was not DigiGroup, it was Blake Plumlee purchasing this. And they knowingly decided to purchase from Blake Plumlee. Now the sellers, as I kind of cutely said, had no dog in this fight, and they unequivocally, and one of them even angrily disagreed. They didn't find out about this, they testified, until they became witnesses in this trial.
Counsel, is the expectancy interest, is it an expectancy interest or is it an expectancy in the relationship? I see language in cases that's you could make an argument both ways. Is it enough that there's just, well, let me ask this. Did they have a relationship or did they just expect to have a relationship? Is it enough that they expected both to have a relationship with each other?
So I thought your question was fascinating when you asked my opponent, and now I understand better. I don't think I can fulsomely answer you on that, honestly, but I don't think I have to. Because here, what the evidence establishes or presents a jury question that they both expected that they were consummating the actual deal. The heck with the relationship. It was the deal. It was the relation. You have relationship and then you have deal. And in fact, tying to, and perhaps why you asked this, my comment just a moment ago, the sellers thought they had. The sellers thought they had, and it's what they wanted. And to the point of them walking away happy, No, that's the very angry testimony by one of the sellers, Darla.
Right, we read the depot.
Okay, so, so I think regardless of whether, and that is a wonderful nuance, and I wish I could engage in that analysis with you better. But I do strongly believe in this case, the facts establish that what would have come from it is in fact the existence of, the deal would have happened.
But we don't have a case to base that model on, correct? This would be a new factual scenario. Where there's a,
Disagree until your last sentence.
Okay.
So the cases say, first of all, I do want to stop for a moment if I can. One of the reasons that their argument fails is that they did not present the argument based on a prospective relationship. Their argument was to misstate the law and said it had to be an existing relationship and not the prospective relationship. So the prospective relationship is that, and I just, to make that point, I think I lost the thread to answering the question you just asked. If you could answer it again, or answer it again.
I wish I could.
Uh,
I think you get my general curiosity though.
Yeah.
If the expectancy can go toward the relationship or it just has to go toward the rights. And if there was any case law which.
Oh, that's what you asked. Is there any case? And now I interrupted you, but I think I understand. No, this is a concept that is case by fact. So it's a situation that we don't have this exact circumstance where a seller's like, oh my gosh, I have a buyer. I'm going to go sell to that buyer, even calling him a targeted buyer. And the buyer's like, oh my gosh, this is exactly what I wanted. And then you have the two perpetrators here like, oh my gosh, we have to keep them apart. Do I have this whole situation in a case? No. That doesn't mean this is a case of first impression or this is the court's going out on a limb applying other case law. It's simply the law of
Your position is we wouldn't be expanding the law
No.
to recognize something that has yet to be recognized.
I wish I'd said it that way. Right. It is simply applying existing law to the facts here. And then what I would suggest if the facts here are so remarkably strong for that law to be applied to. I think one reason why you might not find case law saying it is this circumstance is pretty, unfortunately, pretty unusual.
A little under a minute remaining.
I'm sorry.
A little under a minute remaining.
So some of the arguments were not addressed by my opponent at oral argument, and I tried to provide it, and admittedly, you allowed me to exceed the page limit. Would you like me to address any of those issues now? Do you have any other questions on arguments not raised by my opponents? On the other issues on appeal? I just want to say I very much appreciate the time to appear before you today. Thank you.
You recognize Mr. Sugar.
Thank you, Your Honor.
Counsel, I'm very interested in your thoughts about the idea that there should be a separate framework for determining set off that conflicts with the fourth DCA.
Well, the statutes say what the statutes say. And as people are fond of saying, we're all textualists now, and the statutes don't admit of any exceptions. I see the issue of attorney's fees in a case such as this as over here. A determination was made by the trial court on which fees were awardable and which fees were not. I went along with calling that a haircut because in some sense it is, but it's a haircut that the trial court based on its determination of facts and its application of the law. So they were not denied anything that they were entitled to under that view of the proceedings. They were denied that to which they were not entitled because the case didn't go to trial against RCP. And what they're trying to do is say, okay, we lost over here on fees. We're not entitled to those fees and costs, but we're going to get it back over here.
Well, isn't their argument maybe better stated that they're saying there's no longer an identity of damages because we know that there is no overlap as the attorney fee claim, there's no longer identity for you to subtract from. And I guess your argument would be, we don't know because they didn't differentiate. We don't know what belonged to attorney's fees and what didn't.
Exactly. But the case law is very clear in cautioning. And if you read the case law before you enter into a settlement agreement, you know what to do. And if the other side that you're settling with doesn't want to do that for whatever reason, and you agree because you want the case to go away, then you waive.
How would their framework not be a textualist analysis?
Because there's no exception for a separate attorney's fees award in the
Well,
statute.
I think what their framework would be, you just go to the trial judge and the trial judge is going to ferret out what is what on the settlement agreement and then make sure it is applied based upon his evidentiary findings.
I think the
Is it
case
not
law,
just, sorry, is it not just a different framework for satisfying the same statute?
I would disagree. The case law of which the legislature was presumably aware when it reenacted the statute every year doesn't give trial judges the authority to ferret anything out except was this an aggregate settlement or not?
So it's a soil cannon. It brings the, sorry, go ahead.
I don't think I've ever heard that phrase. The trial judge makes a determination. They don't have to make that determination here, but the judge doesn't have to because they conceded it. It's an aggregate settlement. So that's off the table. The only question is how much? And we're not recovering a nickel more in damages under the settlement than we got from the jury. We got, then they got from the jury that we have to pay. We're not getting out from underneath anything that we're not entitled to get out from underneath. We're just saying we pay it once. We don't pay it twice. And we need to know how much the settlement is to find out if we're paying it once or paying it twice. There's one other point I'd like to make very quickly. I wrote this down because I don't think I've ever heard this before in an oral argument. I don't have to tell the court what it already knows. And talking about the two-issue rule. I've never heard that before, and I think for good reason. I think we're obligated to tell the court what the court knows in making our arguments in an individual brief. And if we don't, we've waived it. And that's what we submit the situation is here on the two-issue rule. We'll rely on our brief for the remainder of the
Counsel, I mean, would you concede in your appeal that there was a possibility that you might win on the tortious interference and you might lose on aiding and abetting or vice versa? Did you know that before you filed your appeal that one issue you might win on and one issue you might not win on?
theoretically, Your Honor, of course.
So shouldn't you have then anticipated that the two-issue rule was going to come up in this court, which, like I said, is replete throughout Florida law and oftentimes mentioned by appellate courts as almost an afterthought at the end of opinions of we've got identical damages on these claims and therefore we don't have to get to claims 2, 3, or 4.
Your Honor, the honest answer to that question is I truly believe that there isn't a factual world in this case where I could win tortious interference and lose aiding and abetting. They arise, if I might, Your Honor, finish answering the question. They arise from the same factual nucleus. There isn't a set of facts here on tortious interference and a set of facts here on aiding and abetting. They're all the same acts. And if you read the 89 pages of brief that my opponent filed, you'll see that there's not a separation. The tortious interference started here and ended here. And the aiding and abetting started here and ended here. They completely overlap. And our overarching point is that whatever happened between Didier and Hirsch, between the Didier group and Hirsch, nothing happened that made CBRE liable because Didier didn't achieve his expectation of making millions of dollars from buying a $9,995,000 piece of property.
Thank you, counsel.
Thank you, counsel.
Thank you, Your Honor.